Hi, everyone. It's 9 o'clock, so I think we can begin now. My name is Sebastián Briceño, and on behalf of HIALSA, I would like to welcome you all to the 8th Harvard International Arbitration Conference. First of all, let me say that I'm thrilled to see so many colleagues and friends among the 1,000 participants that are joining from all over the globe. Before turning it over to my colleague Karim Zein, let me say a word about the topic of this year's conference, Clash of Cultures, Civil and Common Law Traditions in International Arbitration. In 1996, the American political scientist and former Harvard professor Samuel Huntington published his book, The Clash of Civilizations. In it, Huntington argued that in the aftermath of the Cold War, there was going to be an inevitable clash of civilizations. Future wars, he explained, will be fought not between countries, but between cultures. Huntington's ideas were deeply influential on legal scholars working on comparative law and international law, mostly. To some extent, the way in which we understand concepts, such as legal traditions or legal transplants, are rooted in these presuppositions. We refuse to think the interactions between cultures in terms of pure confrontation. The title of this year's conference is precisely an invitation to analyze, throughout the lenses of international arbitration, the constructive ways in which legal traditions can interrelate. In these complex times that have reminded us of the fragility of the rule of law and of international institutions, if there is one takeaway that we would love everyone to have from this conference, is that international arbitration, with all its defects and all its glitches, stands to maintain that even the most complex disputes can be settled peacefully. I will hand it over now to Karim.
Many thanks, Sebastian, for these powerful words, and good morning or good afternoon, everyone, depending on where you're currently located. I wanted to first join Sebastian in welcoming everyone to the 8th Harvard International Arbitration Conference. We are all very excited to count you among us this year, and we hope that you enjoy every minute of this conference. We are particularly proud this year as the 8th Harvard International Arbitration Conference is the most ambitious Harvard International Arbitration Conference so far. This year, as many of you already know, we have 6 different panels, 3 different co-chairs, and a total of 21 superstar speakers of 16 different nationalities. This, we believe, is emblematic of the spirit of this year's conference, which aims to focus on the ways in which the common law and civil law traditions interact through the lens of international arbitration. The online format of this year's conference has also enabled us to reach a very wide audience from different legal traditions and different legal backgrounds as well. With more than 1,000 registrations, the 8th Harvard International Arbitration Conference is currently being watched in 5 different continents. I would like to seize the opportunity to thank our sponsors, without whom the reach of this conference would not have been the same. In particular, I would like to thank first our gold sponsors, White & Case and Debevoise & Plimpton, our silver sponsors, Clary Gottlieb and Von Vobeseri Sierra, and our bronze sponsors, Chaffetz Lindsay, Covington, and Deckert. I would also like to seize the opportunity to thank each of our 25 institutional sponsors and tell them how grateful we are for their constant support throughout the preparation of this conference. And last but not least, I would like to thank everyone watching us today for being here. We hope you have a wonderful conference. On behalf of the entire executive board of the Harvard International Arbitration Law Students Association, I declare the 8th Harvard International Arbitration Conference officially open. Sebastián?
Thank you, Karim. And I think that with that, we could now, without further ado, begin with the first keynote speech of this morning that will be delivered by Dr. Dietmar Prager, and that the title of which is The Role of International Arbitration in Maintaining Peace. Let me say a word about Dr. Prager's biography very quickly. Dr. Prager is a partner at Davis and Plimpton in New York. He focuses his practice on international arbitration and litigation and co-leads the firm's Latin American practice group. Dr. Prager has represented clients in several arbitrations conducted under the rules of all major arbitral institutions around the globe. His recent representations include disputes involving infrastructure, mining, oil and gas, and finance projects, among many others. He also sits as an arbitrator. Prior to joining DEOIS more than 20 years ago, Dr. Prager served as legal officer at the International Court of Justice. He was also one of the youngest lawyers ever to argue before the court. Dr. Prager, the floor is yours.
Thank you very much, Sebastián, and thank you for the opportunity to co-chair the conference and to deliver this keynote address. In this keynote, I will address the role of international arbitration in securing and maintaining peace. And I would like to start with the following example. It involves two major powers. The first is a democracy that within a short span of time has become a superpower and has extended its influence over a large and ever-growing area. The other is an authoritarian oligarchy that is a military powerhouse and the hegemon of an important political and military alliance. Relations between these two superpowers have become increasingly fraught. The growing influence of the rising democratic superpower has caused great alarm among the old military hegemon and its allies. To make matters worse, the democratic superpower has been involved in targeted military operations involving an alliance member of the other superpower and has imposed crippling economic sanctions against another alliance member. A war between the two superpowers appears imminent. And it is in this tense situation that the leader of the democratic superpower decides to make a major public address to his legislative assembly. Invoking a peace treaty with the other superpower, he reminds the assembly that, and I quote, "The treaty provides that all disputes between us should be arbitrated and the awards accepted, each side keeping what it has got in the meantime. But they have not sought arbitration at all, nor accepted our offers to have our differences arbitrated. They would rather settle their claims by war than by words. We are willing to arbitrate according to the treaty. We will not start a war. We are ready to have our accusations adjudicated upon according to the treaty." Now, many of you will have guessed correctly that the two powers I have been referring to are Athens and Sparta. The speech invoking the arbitration clause was given by the great Athenian statesman Pericles. The year is 432 BC. As you might recall from your history class, Sparta did not observe the arbitration agreement. It saw the right opportunity to deprive Athens of its newfound power. What followed was a war lasting 27 years with an enormous loss of human life and disastrous economic consequences. The story of Athens and Sparta shows that arbitration has been recognized as a means of peaceful dispute settlement for millennia, long before the 1794 Jade Treaty between the United States and the United Kingdom, which is often credited as the starting point for modern-day interstate arbitration, or the 1899 Hague Conference, at which the Convention for the Settlement of International Disputes was signed, that recognized arbitration as the most effective and at the same time the most equitable means of settling disputes which diplomacy has failed to settle. The example of Athens and Sparta also shows us that international arbitration agreements cannot prevent wars of aggression. Nobody can seriously argue that international arbitration would have prevented the First or the Second World War, or that international arbitration would have avoided Putin's gruesome war of aggression against Ukraine. So then, when can arbitration serve its mission to secure and maintain peace? I propose to discuss three roles that arbitration can play in securing and maintaining peace. First, by resolving discrete issues in the context of a larger dispute. Second, by settling mass claims arising in relation to an interstate conflict. And third, by addressing ancillary issues alongside the main dispute. And in discussing these three roles, I will draw on prominent examples of international arbitrations conducted, not in ancient Greece, but more recently since World War II. I will attempt to highlight both successes as well as shortcomings. The first role arbitration has often played in public international disputes is in resolving discrete political issues, including boundary disputes, that parties have deferred to arbitration. This often occurs as part of peace talks after an armed conflict, but agreements to arbitrate such issues have also been made before a cold conflict turns hot to preempt the resort to force. I will briefly discuss three illustrative examples. My first is the 1988 Taba arbitration between Egypt and Israel. This dispute had its roots in the 1979 peace between the two countries, according to which Israel withdrew from almost all of the Sinai Peninsula. But, citing historical maps and other documents, Israel declined to relinquish Taba, a 700-yard-long section of coastline that during the military occupation had become the site of a multi-million-dollar resort hotel built and operated by an Israeli businessman. The boundary dispute remained a sticking point between the two countries even after the peace deal, and in 1985, the Reagan administration stepped in to help the parties find a solution. After years of negotiations led on the US side by then State Department legal advisor Abraham Sofer, the parties agreed to a compromise that would refer the dispute to a tribunal of 5 arbitrators, one from Egypt, one from Israel, one from France, Switzerland, and Sweden. 3 years later, the tribunal, with a lone dissent from the Israeli member, ruled in favor of Egypt. Israel ultimately withdrew from the area in compliance with the decision within a year of its publication, marking the first time Israel and an Arab government achieved pacific settlement of an international dispute. Writing in 2017, Abraham Sofer lauded the successful award in that it helped the parties prevent the issue from causing a deterioration of their relations. But he noted that the arbitration was actually only one part of a substantial effort that enabled diplomacy to prevail. He went on to chronicle 18 months of intense negotiations to achieve the compromise and a further 5 months of negotiations after the award to ensure that Israel implemented it. In my second example, arbitration combined with mediation helped to cool what was a hot conflict. In 1971, Argentina and Chile signed an agreement referring to arbitration the question of sovereignty over several islands in the Beagle Channel at the southern tip of South America. The islands themselves were small, but the demarcation had significant implications for shipping in the southern Atlantic. After hearing in Geneva, the 5-member tribunal awarded to Chile all the islands and navigable waters, but one corridor on the eastern part of the channel. Argentina initially refused to accept the award and mobilized its military to invade the islands. The two countries came to the brink of war, but agreed in the last moment to mediation by the Vatican. And that mediation by the Vatican was successful, so the two parties agreed to accept the arbitral award in the 1984 Treaty of Peace and Friendship. Yet not every attempt to settle a boundary dispute by arbitration has led to an ultimately successful outcome. My third example is the Abyei arbitration, a case from 2009 between the Republic of Sudan and the Sudan People's Liberation Movement Army, or SPLMA, a political party and armed group agitating for the independence of what is today South Sudan. The arbitration came after Sudan and the SPLMA had fought over 2 decades of civil war, leaving millions of civilians dead or displaced. The conflict had deep roots in long-standing cultural, religious, and political tensions between the predominantly Muslim and Arab North and the largely Christian and indigenous African South. The discovery of oil fields in the late 1970s and early 1980s that straddled the north-south border exacerbated these tensions as the parties sparred for control over them. In 2004, Sudan and the SPLMA agreed to end the fighting and to hold 2 binding referenda. The first would be held in southern Sudan on whether to become an independent state. The second would be held in Abyei, an ethnically mixed border town and site of ongoing intercommunal violence, on whether it would be part of the north or the south. But before the Abyei referendum could be held, the 2 sides had to settle an ongoing dispute over the borders of the Abyei area to establish the electorate for the referendum. The demarcation of Abyei's borders was thus critical to ending the war. After 4 years of negotiation and conciliation, again supported by international mediators from the United Nations, the US, and the UK, Sudan and the SPLMA agreed to submit the boundary dispute to binding arbitration under the auspices of the Permanent Court of Arbitration. The hearing at the Peace Palace seemed to reflect the highest ideals of the 1899 Hague Conference. Delegations from the warring parties met in the wood-paneled courtrooms where some of the leading lights of the international bar argued their case before a prominent panel of 5 arbitrators, including 2 former ICJ judges. Summing up, Gary Bourne, the SPLMA's counsel, wrote that the arbitration produced an erudite award authored by very experienced authorities on international law and adjudication, whose language affirmed the rule of law in ringing terms. The award set new boundaries for Abyei, decreasing by around 40% the land that international experts had previously recommended comprised the area, but leaving valuable oil fields to both the Republic of Sudan and groups aligned with the Southern independence movement. The tribunal, aware of its crucial role within the Greater Sudanese peace process, observed in its award that it had, I quote, done its utmost to contribute through the task assigned to it to a peaceful resolution of the bitter conflict over the Abyei area within the time limits prescribed by the arbitration agreement. And yet, as Gary Bourne noted, the tribunal's diplomatic solution produced neither peace nor a stable Sudan. The award did not put an end to either the border dispute, which continues to this day, or intercommunal violence among the area's 125,000 residents. Fighting broke out again in Abyei just 2 years after the tribunal published its award. 4,500 UN blue helmets are working to maintain peace, though only this month, intercommunal violence killed dozens of civilians and displaced hundreds more. The Abyei arbitration is an important and tragic case study because it reveals both the promise and the limits of the role arbitration can play in securing peace. Although it is impossible to say how the conflict might have evolved had the tribunal not been constituted, it is hard to avoid concluding that the Abyei arbitration worked better in theory than in practice. None of this, of course, is the fault of the arbitral tribunal. One takeaway here is that submitting a discrete issue to arbitration will only help resolve the underlying dispute if that dispute is otherwise ripe for resolution. The technical questions within the Abyei tribunal's jurisdiction simply could not paper over the deep, unresolved intercommunal tensions that had plagued Abyei for decades. The second way arbitration has contributed to peace is in the settlement of mass damages claims arising out of conflicts. The use of arbitration to settle mass claims arising out of war dates to the earliest modern examples of public international arbitration. Two of the three arbitral commissions established by the Jade Treaty that I mentioned earlier were in fact mixed claims commissions set up to handle a large number of individual compensation claims arising from the American and French Revolutionary Wars, in particular with regard to pre-war debts and disruptions to shipping and other maritime violations. A more recent example is the Iran-United States Claims Tribunal, which was established as an essential element of the deal to address tensions between the two countries arising out of the 1979 Iranian Revolution and the hostage-taking of 52 Americans from the US Embassy in Tehran. The Iran-US Claims Tribunal offers a rare example of a mass claims process that may have prevented a hot war between two states, as opposed to resulting from one. The need for a mass claims process arose out of the deep commercial and economic ties between the two countries that predated the revolution. At the time of the Shah's fall, hundreds of contracts were then in force between the US and the Iranian governments, including contracts for military equipment, and many more between US and Iranian companies. When the Islamist regime took power in Iran, the military sales relationship collapsed. This left hundreds of millions of dollars of outstanding claims between the two governments and their citizens. US claims for breached contracts and expropriated properties, Iranian claims for the delivery of equipment that Iran had already paid for but not received. The US and Iran had severed diplomatic relations, leaving no forum in which to settle these disputes. The countries worked through Algerian intermediaries to negotiate the Algiers Accords, in which Iran agreed to release the hostages in exchange for the United States unfreezing of certain Iranian assets. The accords also established the Iran-US Claims Tribunal in The Hague to settle the outstanding commercial disputes, including many claims for which American companies had already filed lawsuits in US courts. Iran made the release of the hostages contingent upon the transfer of the pending claims to the tribunal. The tribunal consists of 9 members, 3 appointed by each government and 3 who must be third country nationals appointed by the 6 members. The tribunal has jurisdiction not only to decide certain commercial claims of US nationals against Iran and Iranian nationals against the United States, but also certain official claims between the two governments. Its procedures are governed by the Ancillary arbitration rules with some specified modifications. One of the most notable things about the tribunal is its continued successful operation over the last 40 years, even as the relationship between the United States and Iran otherwise reeled from crisis to crisis. The US has continued to participate in the tribunal throughout withdrawing from the Iran nuclear deal, imposing additional sanctions on the Islamic Republic, and designating an element of its armed forces as a foreign terrorist organization. It is remarkable to recall that, since 1979, the tribunal has been the only forum in which US and Iranian government officials have regularly met in public. That is perhaps one reason why the two states have not put pressure on the tribunal to wind up its work, even as some of the claims before it have been pending for decades. Even more recently, mixed claim commissions have attempted an ambitious new role to provide redress to victims of war crimes and other violations of human rights and humanitarian law during armed conflict. An example of this is the Eritrea-Ethiopia Claims Commission. The EECC, as it is known, sought to resolve claims arising out of an armed conflict that had erupted between Ethiopia and Eritrea in 1998 over a border dispute. After more than 2 years of fighting, which resulted in an estimated 50 to 100,000 dead, almost 1 million people forcibly displaced, and widespread devastation, the two states signed a peace agreement in December 2000, also known as the Algiers Agreement. Among other things, the Algiers Agreement established a neutral commission with a broad remit to decide through binding arbitration all claims for loss, damage, or injury by one government against the other and by nationals of one party against the government of the other party, as long as the loss resulted from violations of international humanitarian law or other international law. The commission was seated in The Hague, with the Permanent Court of Arbitration serving as registry, and based its procedural rules on the PCA optional rules for arbitrating disputes between two states, which are in turn based on the UNCLOS rules. The EEC issued final damages awards in August of 2009 of about $161 million to Eritrea and about $2 million to individual Eritreans, and approximately $174 million to Ethiopia, amounts that paled in comparison to the billions of dollars in damages the two states had claimed. The Commission conceded that the awards were deeply discounted in relation to the actual losses suffered due to concerns about the reliability of evidence and the state's modest financial resources. Further, the damages have apparently never been paid, and no individual victims who bore the brunt of the losses appear to have received any compensation. So what went wrong? Well, first of all, some things did go right. The commission, which was set up of eminent arbitrators, tackled massively complicated questions of state responsibility, not only for violations of jus in bello, but also for the jus ad bellum, ultimately finding breaches by both parties through a process generally perceived to be fair and legitimate. In so doing, the Commission greatly contributed to the progressive development of substantive norms of international humanitarian law, as well as to evidentiary and procedural standards for international humanitarian law damages claims in international fora. But the EEC also had to take on too much in too little time. It had a mandate to hear both state-to-state claims and mass claims brought by the state on behalf of individuals. The latter option was largely abandoned as the governments chose to focus on the interstate claims. The government's decision to focus on a consolidated set of interstate claims rather than a mass of individual claims also may have related to timing. Because the Commission's remit was so broad, the two states filed a huge variety of claims encompassing all manner of IHL and human rights violations. But the Algiers Agreement imposed an unreasonable deadline for the final arbitration of within 3 years after the filing deadline, a timeline the Commission was required to extend. Ultimately, the lofty and laudable goal of the EEC to provide individual claimants with compensation for IHL violations through interstate arbitration may have been the primary architect of its own downfall. Modern mass claim procedures that have succeeded in processing and paying out large numbers of individual claims for conflict-related damages have tended to focus on property claims and other more easily quantifiable commercial losses. For example, the UN Compensation Commission, established to process claims for damage related to Iraq's 1999 invasion of Kuwait, is largely considered a success, deciding 2.7 million claims in less than 15 years and awarding a total of $52.4 billion to approximately 1.5 million successful claimants. The UNCC paid out tens of billions of dollars more for property and business-related losses than for claims of death and other personal injury. The UNCC's success, in contrast to the EECC, could also be attributed to the higher level of international support for its creation and operation. The UNCC was established by Security Council resolution and well funded by a special account from the sales of Iraqi oil. But the UNCC's design undoubtedly played a key role as well. It prioritized individual claims and applied a lower evidentiary threshold to them. And although the UNCC did allow for personal loss claims, it evaluated claims through an administrative process that did not require the commissioners to tackle complex legal questions of state responsibility under international humanitarian law, aided by the fact that Iraq had accepted responsibility for damages arising directly from its invasion of Kuwait before the commission began its work. As a result, the UNCC was able to focus on verifying claims as a fact finder rather than assigning liability. These examples speak of the limitations of arbitration in providing redress to individual victims of war crimes and other violations of human rights during armed conflict, which can be a key component to building a sustainable peace. Ultimately, the EEC could achieve little to secure regional stability. Ethiopia and Eritrea did not fully implement the Algiers Agreement until 2018, and war broke out in the border region again in 2020. The final role of interstate arbitration I would like to discuss, the arbitration of issues that are ancillary to the underlying dispute, which remains outside of a tribunal's jurisdiction. There are several reasons why a state might pursue this option. The two states might not be party to a treaty that would confer jurisdiction on a court or tribunal that could adjudicate the core issue. The real dispute might just be too complex to be appropriate for judicial settlement. Or maybe the ancillary issues remain important, even if it does not get to the root causes. These arbitrations can lead to mixed results. Interstate arbitrations under Annex VII of the UN Convention on the Law of the Sea provide two such examples. First is the South China Sea arbitration between the Philippines and China. As you will know, the South China Sea is one of the most strategically important bodies of water in the world. 1/3 of the world's maritime shipping passes through it, carrying over $3 trillion worth of goods annually, a critical link to China's global Belt and Road Initiative. The sea's fish stock are crucial to food security in China, the Philippines, Taiwan, Malaysia, and the other coastal populations that surround it. And it is believed that tremendous oil and natural gas reserves lie under the seabed. Control over the South China Sea has been a flashpoint between China and the other littoral states. China, for its part, has been seeking to project its exclusive control over the South China Sea. Specifically, China has gotten into the island building business. For what has been termed the Great Wall of Sand, China has been shipping in boatloads of soil and gravel to build up uninhabitable rocks, shutting out just above the waterline into full-blown islands. According to the US Navy, China has militarized at least 3 of the newly formed islands, arming them with fighter jets, anti-ship systems, and other weapons. Now, the UN Convention, UNCLOS, does not regulate national security, island building, or sovereignty over land territory. But it does regulate states' entitlements to make use of the sea extending out from their coastlines. Specifically, states are entitled to an exclusive economic zone, which includes shipping, fishing, and exploitation rights within 200 nautical miles of the coast or other relevant coast baseline. The trick here is that under UNCLOS, the EEC entitlement cannot extend from a rock, but it does form from an island. And China has been relying on its newly created islands to claim exclusive economic rights over large swaths of the South China Sea. The dispute with the Philippines arose in part because the Chinese Navy kept kicking Filipino fishing vessels out of its alleged EEC. In referring the dispute to arbitration, the Philippines asked the tribunal to decide whether China's new platforms of sand were rocks or islands for purposes of UNCLOS. China did not formally participate in the proceedings, though it did persistently object to the tribunal's jurisdiction and refuted the Philippines' claims on the merits in public statements, including a position paper posted on the website of its Ministry of Foreign Affairs. The eminent tribunal members rightly applied the Vienna Convention on the Law of Treaties to engage in a close reading of Article 121, paragraph 3 of the Convention, which provides that rocks which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf. The tribunal devoted several paragraphs to interpreting each word or phrase in the first half of that article, relying on sources such as the Oxford English Dictionary. In July 2016, the tribunal ruled for the Philippines on virtually all counts. Unsurprisingly, China has refused to comply with the decision and continues to build and occupy man-made islands. Meanwhile, regional and global tensions continue to rise. Most recently, the AUKUS deal between the US, the UK, and Australia over the sale and purchase of nuclear submarines was meant in part to allow Australia to step up its naval patrols in the South China Sea. It is too early to tell what impact the arbitral award will have in the long run, if any, but for now, the status of the South China Sea appears to sit squarely in a world of diplomacy and comparative economic and military might. The second case I wanted to mention is a pending Annex VII arbitration that Ukraine initiated against Russia in April 2019. Formally, the dispute concerns Ukraine's rights to regulate fishing, exploit natural resources, and pass ships through what Ukraine considers its territorial sea and EEZ around the Crimean Peninsula. But clearly, the parties would not be in arbitration had Russia not annexed Crimea in 2014. This gave rise to a preliminary objection from Russia that the real dispute was a question of territorial sovereignty, over which an Annex VII tribunal has no jurisdiction. The South China Sea Tribunal had rejected a similar objection from China, holding that China's sovereignty over the rocks-turned islands was not in dispute. In the Ukraine v. Russia case, however, the tribunal was unable to disentangle Ukraine's claim of territorial sovereignty over Crimea from its requested relief in respect to maritime entitlements. The tribunal held that, although Ukraine formulates its dispute with the Russian Federation in terms of the alleged violation of its rights under the Convention, many of its claims are based on the premise that Ukraine is sovereign over Crimea, and thus the coastal state within the meaning of the various provisions of the Convention it invokes. Therefore, the tribunal said the real issue of contention between the parties is whether there exists a sovereignty dispute over Crimea. The tribunal acknowledged that Annex VII tribunals can take jurisdiction over minor ancillary issues that are necessary to decide to reach the dispute referred to it. Here, however, the tribunal held that territorial jurisdiction over Crimea was not a minor issue ancillary to the dispute concerning the interpretation or application of the Convention, but rather a prerequisite to deciding many of Ukraine's claims. The tribunal accordingly found it did not have jurisdiction over almost all of Ukraine's claims, except for two issues related to coastal and shipping activities in the Sea of Azov and the Kerch Strait, where the question of territorial sovereignty over Crimea was irrelevant. The tribunal ordered those issues to proceed to the merits. Russia is due to submit a counter-memorial in that case on August 22 of this year, though the current situation must raise doubts about the future of this arbitration. So, to conclude, what lessons can we draw from the various roles international arbitration has played in securing peace since World War II? Arbitrations have played an important role in resolving conflicts It's a forum for working out discrete issues on which parties were unable to agree during diplomatic negotiations. This seems particularly true for political issues with an embedded legal question, such as boundary disputes. Arbitrating such issues can also serve as a release valve for domestic political pressure, allowing states to punt decisions that are likely to be unpopular at home to a neutral arbiter in a respected international forum. Arbitration can also assist in the resolution of mass damages claims arising from an armed conflict or other disruption in interstate relations. Thus far, however, arbitral tribunals have proved more effective in settling such claims when they are commercial or otherwise economic in nature, as opposed to addressing the losses suffered by victims of war crimes or other human rights violations. Although this may be disappointing, it is hardly surprising. Losses that flow from violations of international human rights or humanitarian law are at once more devastating and harder to prove and quantify. Finally, arbitration can tackle ancillary issues adjacent to conflict, if there truly are arbitrable ancillary issues. But parties that attempt to shoehorn the broader political dispute into an arbitration clause that was designed for other purposes will likely find themselves disappointed. Overall, arbitrations seem most successful when they support or are supported by robust diplomacy between the disputing parties or by mediation. For that reason alone, we know that arbitration is not right for every conflict. The parties must be willing to accept the rule of law, and the issues in dispute must be discrete enough to give arbitration a chance for success. Arbitration is not a panacea that can secure peace in every context. To use international arbitration to its greatest effect, we must be aware of its limitations. But history tells us that the flexibility arbitration affords parties to determine a tribunal's procedure and scope can make it a powerful tool to supplement diplomacy or even extremely contentious conflicts between disputing parties. And it is in this flexibility of arbitration that its greatest promise lies in the future. We will never rid the world of war, but we can strengthen our available tools, including international arbitration, to build and secure peace and the rule of law that ultimately will always prevail. Thank you very much.
Thank you very much, Dr. Prager, for this very interesting and thought-provoking and empowering presentation. On behalf of the Executive Board of HIALSA, we want to thank you once again for accepting our invitation. We are truly honored. I think we have a 16-minute break, and we will gather again at 10 a.m. EDT for panel 1, which will be discussing good faith in common law and civil law traditions. Thank you, and see you all at 10.
Welcome back, everyone. We're gonna go now with panel number one. The title of this panel is "Good Faith in Civil and Common Law Traditions, Antagonistic Doctrines." So before we jump in, let me very briefly introduce the speakers of this panel. Mr. Nigel Blackaby, here with us, is based in Washington, D.C., and he's the global co-head of Freshfield's International Arbitration Practice. He has acted as counsel and arbitrator in over 100 ad hoc and institutional arbitrations, both commercial and investor state. He was appointed as Queen's Counsel in 2020, and he's the co-author of the 4th through 6th editions of Brethren Hunter on International Arbitration, and he's also the co-author of Kluwer's Guide to Exit Arbitration and International Arbitration in Latin America. He's a member of the Court of the Singapore International Arbitration Center. We also have with us Sarah Vasani. She's a partner at CMS based in London, when she is the co-head of International Arbitration. She has ample experience in both commercial and investment arbitrations, representing clients before all key arbitral institutions. Ms. Vasani is dual qualified in England and Wales and also in the US. And finally, we have Roland Ziadé. He's a partner at Linklaters based in Paris, where he is the global co-head of International Arbitration. He has acted as counsel in around 100 international arbitrations. Mr. Ziadé he also acts as an arbitrator and has sat in over 45 international tribunals. He earned his LLM degree from this university, Harvard Law School, in 2002. So without further ado, Ms. Vasani, the floor is yours.
Thank you so much. And I hope everyone can hear me. I think Roland and I, are we both in Paris right now? And enjoying Paris Arbitration Week as well. So Nigel, are you here or are you in Washington?
Actually in New York, but so I'm not enjoying Paris Arbitration Week. It's just a very cold and gray day here in New York.
Well, it is likewise cold and gray here in Paris, but at least we're in Paris, and that says something.
And you have macaroons, so that's good.
Exactly, we have macarons, and we have just the beautiful sights of Paris as always. So today we're going to talk a little bit about good faith, which spans, both civil law jurisdictions, common law jurisdictions, and indeed international law. And what we'd like to start out by doing is each of the panelists will give a respective kind of overview of civil law first. Roland will take that. And then we will also discuss, interestingly, I think, Nigel, you with the English accent will be discussing U.S. law in good faith, and I with my American accent will be discussing the law of England and Wales in relation to good faith. So with that overview, we'll then turn to any questions that I'll be posing to the panelists, and likewise, if there's any questions that anyone of you have. I don't know if there's a means of producing them, but feel free to pass them to Karim if you're in the room with him, and we'll happily address those as well. So with that, I'd like to first hand the floor over to Roland.
Oh, good morning, good afternoon, all, wherever you are. So good faith is a concept we all know, have heard of, have studied, or even relied upon in cases from a procedure or substantive perspective. But it is also, I would say, a concept that we can't easily define or apprehend with real precision. As mentioned and stated by a prominent practitioner, good faith is like an elephant, being easier to recognize than define. It has also been noted that the lack of precision is a defining feature of the duty of good faith, providing the flexibility required for balancing the rights of the parties. The tendency of international arbitrators to resort to the principle is well known. Bernardo Cremades went as far as to say it is difficult to find an international award, I'm quoting him, that is not based or at least does not mention good faith, end of quote. Why? Because even if this is debatable and even questionable, there may be a tendency of an arbitrator to give greater place to equity than a national judge would do. There is no doubt that good faith is a key and quite typical civil law concept, since I'm focusing on that. However, its former reputation as making common law jurists queasy is, I submit, not that well deserved, and it's a concept that is not as hazy and foggy as it may appear to a common law lawyer. They may disagree. And here we'll be contrasting, as you know, civil law and common law. As stated by an ICC award, I think of 2015, the ICC award 19890, which was rendered under Swiss law, the principle of good faith comprises many different aspects of substantive and procedural nature. As a result, there is, as such, no precise or widely accepted definition of the concept of good faith in a contractual context. It is a vague standard. Its meaning and effect are therefore likely to vary considerably depending on the context. Generally, one can also say that an obligation to behave in good faith is likely to require that the parties observe a reasonable commercial standard of fair dealing, be faithful to the agreed purpose of the agreement, and act consistently with the legitimate expectations of the other party. Long quote, but end of quote. Now, as indicated by a French law professor, good faith is a fluid behavioral standard, but a standard that is not a license to kill or shortcut the legal reasoning. Indeed, the duty to act in good faith has arguably some solid and specific legal effects. Some may even say some welcome legal effects. Before I address them, let me first emphasize that there should be no doubt that good faith is a key concept in civil law systems. For instance, Article 1104 of the French Civil Code, the former very well-known 1134 of the Napoleonic Code, sets out that contract must be negotiated, formed, and performed in good faith. And the statute now adds this provision is a matter of public policy. I can also refer you, among others, to the Swiss Civil Code, to which the ICC award I mentioned referred, to the German BGB, as well the Italian, Austrian, Romanian, Polish, Spanish, Portuguese code, which all contain similar provisions. Outside Europe, the situation is the same, and even outside the realm of the former continental European colonies, such as jurisdiction which used to be French colonies or under French mandate, like my country of origin, Lebanon. And for example, the Egyptian Civil Code also contains such a duty. It states that, and I quote, a contract must be performed in accordance with its content and in compliance with the requirement of good faith. And when one knows the influence of Egyptian law on the civil laws of the Middle Eastern jurisdiction, it speaks volumes. Similar provision can be found in a number of other jurisdictions, civil law jurisdiction in Asia, Africa, and Latin America. Among the main differences between the civil law tradition and English and American law, and you will hear more about the distinction between civil law and common law from my co-panelists, and between both English and American law, are the fact that under civil law, good faith is usually imposed not only for the performance of a contract, but also for its negotiation. And public policy can limit the will of the parties under certain legal system like France. One cannot relinquish such a duty even by agreement of the parties. Things are such today that good faith may well be considered by some as a principle of lex mercatoria, assuming you believe in lex mercatoria. In that respect, Article 17 of the Unidroit principle sets out clearly that each party must act in accordance with good faith and fair dealing in international trade. And indeed, the uni-droit principle have their root in the civil law legal culture, while common law is arguably more allergic to, at least less attracted by general principle. And this might be one of the main explanations for the common law lawyers' reluctance to good faith, i.e., the reluctance to concept looking very abstract in general. As indicated in ICC award, there is no general doctrine of good faith for commercial contract governed by English law, and if the party wish to impose such duty, they must do expressly. We'll get back to that. That said, despite such a broad statement, isn't it in fact often, not always, the real contrast between both legal systems more a result of the way we answer a question and resolve the problem than a difference in the substance of the answer or the outcome? Indeed, even if common law and English law in particular has characteristically not committed itself to such overriding principle, it has, and you'll hear probably from that, developed piecemeal solution in response to demonstrated problem of unfairness, from misrepresentation to economic duress, undue influence, promissory estoppel, unjust embarrassment, impracticability, and reasonableness, which could lead in some instances to similar outcome. But I'll defer to other on that. Civil lawyers tend to resolve on the basis, as I've mentioned, of a general concept, and the answer to the solution in light of the fact by way of some form of successive deductive reasoning. Good faith is one of those very broad, very general concepts we start by, and is therefore a very typical civil law tool. It is a concept prone to generate particle solutions slowly, crystallizing in specific legal institutions, which can be crafted by case law and being sometimes ultimately enshrined in certain statutory rules. The breach of that behavioral norm supposes to positively prove what is the conduct at stake in the contractual relationship and what is wrong, mistaken in that conduct. But how, in fact, to assess such a wrongfulness or such a breach even? It has been submitted that one could probably do so with reference to three set of norms, which were all touched upon in the ICC award under Swiss law that I mentioned earlier. The first one is honesty. It's difficult to define what is positively and in the abstract honesty. For example, deceit is a clear-cut dishonesty, but how transparent must one be? To what extent must one share information that may be relevant to the other party? As too often, it will depend. The second norm is the reasonableness. And do you think that the common law lawyer would disavow that concept of reasonableness? Certainly not, I submit. That calls for a duty of some form of moderation, proportionality, or self-control in the implementation of one's right and in one's conduct in the performance of the contract. For instance, when a delay or a default or a form of dissatisfaction occurs, it advised not to react in a disproportionate manner. And the third norm is reliability, consistency, or coherence with the agreed purpose of the contract. Good faith in the performance requires that parties refrain from hindering the performance of the contract and positively act so as to favor its completion. One ought to act consistently with the legitimate expectations one triggered. As you may realize, we are probably not that far away from the concept of promissory estoppel. Of course, those references do not aim at turning, as indicated by a scholar, each contracting party into a saint, but at least into being a reliable counterparty. Now, what is the duty of good faith directed to? In a nutshell, one could say in two directions. The first is performance-oriented. It commands party to behave as required to fulfill the promise of the contract in application of the letter of the agreements, and beyond the letter, in the spirit of the provision, I would say, the objective is to act so that the contract may deliver its promise, its economic utility. And in that sense, the duty of good faith fosters the principle pacta sunt servanda. And second point, the good faith also invites a party to consider the other party's interest. And that is perhaps one of the most interesting, but also most controversial aspects of the duty. For example, for the duty to give sufficient prior notice before termination without fault, so as to let the other party have time to reorganize and potentially mitigate any adverse consequence of the termination. In many circumstances, good faith may also imply refraining from acting without reason in a way that would harm the other party. Under French law, it has been underlined that the concept, in part, is subjective judgment to a specific set of facts, such that what good faith ought to compel the parties to do must necessarily be case specific. To avoid a common misunderstanding with regard to the duty of good faith, it must be emphasized that its intensity, i.e., the force of its demand, is not the same from one relationship to another. It is again very fact specific and sensitive in this regard, depending on the expectation that one party has created, depending on the confidence that one party could legitimately put in the other, and depending on probably the type of contract at issue. Cooperative contracts such as joint venture agreement, long-term agreement, fiduciary relationship have therefore the highest degree of good faith requirements, at least in practice. And increasingly, the court has strived to place the good faith obligation into the modern contractual setting. Before I conclude, what are now the effects of good faith under civil law? Even if good faith is somehow a fluid norm, it may give birth to quite solid rules. But beside that, it irrigates, it nurtures many areas of the law. And since this is an arbitration conference, we see, for instance, a number of arbitral rules expressly and explicitly referring to the duty to act in good faith in an arbitration. These include the Swiss rules, but also the LCIA rules. For example, Article 32 of the LCIA rules provides that for all matters not expressly provided by the arbitration agreement, the LCIA court, the registrar, the tribunal, and the tribunal secretary, and each of the parties shall act at all times in good faith, respecting the spirit of the arbitration agreement. And Article 14.5 of the LCIA rules also provide that the parties to the arbitration shall at all times do everything necessary in good faith for the fair, efficient, and expeditious conduct of the arbitration. And this is the London Court of International Arbitration rules, which may show that the civil law common law divide on the subject is arguably, a bit provocative, no longer what it used to be. Some even argue that the very nature of an agreement to arbitrate carries with it an obligation to cooperate, whether or not it is stated expressly in the rules. Good faith is also an element of not such specific legal mechanism, but of, I would say, very broad and essential legal rules. A few key rules of contract law refer to good faith as some central element of their operation. For instance, you have the interpretation rules. Article 1188 of the French Civil Code refers to the understanding of a reasonable person when you cannot ascertain what is the genuine common intent of the parties. So where the genuine intent of the parties cannot be discerned, a contract is to be interpreted in the sense which a reasonable person placed in the same situation would give to it. Those rules show some form of overlap between good faith on the one hand and reasonableness on the other. There is also the issue of the completion of the contract, supplementing a contract, as a general mechanism that coincide with the demands of good faith, arguably. The French Civil Code refers to the consequences which are given by equity and usage also. And one can also legitimately ask whether the concept of hardship and the duty to renegotiate a contract due to a change of circumstances originate in the duty to perform in good faith, and whether the correction of unfair terms also originate in good faith. Many scholars have advanced that position. While one effect of the duty to act in good faith is to inspire other rule as a foundational concept, it may also have some standalone effect. I will mention one briefly before concluding. The duty allows for the neutralization of the exercise of a right or the bad faith exercise of the contractual prerogative that the party benefit from. It therefore, in a sense, overlap with the doctrine of abuse of right. For example, under French law, the abuse by a party of its contractual right constitute a violation of a general duty to perform in good faith. There is a landmark case of the French Court of Cassation, which held that the rule of contract must be performed in good faith, allow the judge to neutralize the disloyal use of a contractual prerogative. It doesn't mean that the provision is stricken out, but it's neutralized. So I see that time is running. So to conclude, and maybe to sum up, I would say that good faith is or might be a broad and quite open norm, but it is not a totally wide open one. Good faith is flexible, but there is a logical, conceptual framework which tend to guide its application. And as indicated by a scholar, it's an inspirational concept for some of the rule, a concept with some specific effects, legal effects indeed, a concept rich in potential, but not with any and all effects. That's what at least one can say when assessing the good faith concept and norm from a civil law perspective. And even if civil law and common law have clearly, undoubtedly, and obviously very different starting point regarding the relevance of the doctrine of good faith, they are arguably increasingly moving towards each other's, or at least I am tempted to submit so, partly to be provocative and partly because I mean it. Thank you.
Thank you so much, Roland. That was extremely interesting and a great commentary on the civil law perspective. And indeed, you said a number of things which I think might resonate with common law lawyers as well. So we will hear from Nigel now on the U.S. perspective of good faith and see if he agrees with your assertion that indeed they're moving closer to one another than they ever have before. Nigel?
Thank you, Sarah. Good morning, everybody. I'm honored to return to speak at the Harvard International Arbitration and Law Society conference, and I thank Karim and Sebastián for their excellent organization. It's a great pleasure to share the floor with Sarah and Roland. As we've heard from Roland, good faith is a topic that arises persistently in arbitrations. I lose track of the number of times I've argued or defended good faith in the negotiation or performance of contracts in an arbitration context. But perhaps that's not surprising because many arbitrations, international arbitrations, concern high-value, long-term contracts that we could loosely call relational contracts, where the parties have a long-term relationship which requires cooperation, and that for some reason or another, that cooperation has broken down and the relationship has turned sour. These are often joint venture contracts, partnerships that develop commercial opportunities, franchise agreements, distribution agreements, joint investment agreements. Now, I'm going to speak very briefly on the concept of good faith in both the US and then briefly on international law, and provide some practical examples from arbitrations that I've participated in. I think practical examples are key precisely for the reasons that Roland identified. This is something that is easy to put general definitions around, but those general definitions don't really have much meaning until you see how they're actually applied in practice. This is always ultimately a fact-specific exercise. Now, we've heard a civil law position from Roland. In civil law, you can't escape good faith. Whether you want it or not, it's there. It's in the civil code, and it tells you you have to act in good faith, not just in the performance of a contract, but something which is rather strange to a common lawyer in the negotiation of a contract, where most common lawyers would think that you owe a duty to yourself and that it's really up to the other side to look after its own interests. Now, the position in the United States is less extreme, and it's probably a middle ground between the position in England and Wales and the civil law countries. First, let's remember that this is not one jurisdiction, but 50. So we need to be careful of generalities, and there are some specific differences that can have an impact. Just by way of example, in Illinois, in order to plead a breach of the implied duty of good faith, you need to be claiming a specific breach of another part of the contract or another clause of the contract, whereas in New York, you can have a standalone action for breach of the implied covenant of good faith. But having said that, there is a large degree of consistency between the states on this question. Now, the duty is kind of expanded here to what is generally being called the duty of good faith and fair dealing. And there's a slightly different content to each of those elements. Now, US courts, unlike courts in England and Wales, which Sarah will come on to discuss, have consistently recognized that every contract implicitly contains a duty of good faith and fair dealing. For example, the Uniform Commercial Code. Now, the Uniform Commercial Code is not a federal law, but it's a uniformly adopted state law. So it doesn't apply to certain things, doesn't apply to service contracts. It has a very specific purview. But in the purview that it has, each state will have its version. And the UCC establishes the duty of good faith for commercial transactions that it covers, as every contract or duty within the Uniform Commercial Code imposes an obligation of good faith in its performance and enforcement. So that is generally considered to be the standard to which most states will adhere with regard to those contracts that fall within the purview of the Uniform Commercial Code. Now, you may also be familiar with the second restatement of contracts. Now, for non-US lawyers, this is a kind of super treatise that has special value for judges and lawyers. It seeks to inform judges and lawyers about general principles of contract common law applicable in each state. And the restatement concludes that when parties perform obligations under a contract, they must act in accordance with the agreed purpose of that contract. And once again, we see similar language to the UCC. Every contract imposes on each party a duty of good faith and fair dealing in its performance and enforcement. Not its negotiation, its performance and enforcement. And indeed, he goes on to make reference to bad faith, which is the equal and opposite, and that bad faith violates community standards of decency, fairness, and reasonableness. So we seem to have a consensus that in the United States, contracts have an implied duty of good faith and fair dealing. That's great. What does it actually mean? Now, in terms of scope, most jurisdictions have held that neither duty can override express contractual provisions. So if you've got an express contractual provision that requires certain conduct to be in good faith, that you shall undertake your best endeavors to procure a license, or something that overlaps with regard to the implied duty of good faith, you must rely on the express term. In a sense, it's a gap-filling implied term in that regard. You don't rely on the same facts to assert a breach of contractual obligation and an implied obligation of good faith and fair dealing. So it's there to make it clear that in every contract it exists, but if a similar provision exists in the contract, you should be relying on the contractual provision. But when it does apply, courts have, just as they do in civil law countries, considerable discretion to determine its scope. Let's break down the duty into two layers: the duty of good faith and the duty of fair dealing. Now, the duty of good faith implies the parties must conduct themselves honestly during the performance of a contractual agreement. No dishonest conduct, loyal conduct towards your contractual counterparty. And then case law develops what that means. Fair dealing has generally been considered to require something more than just honesty. It requires that the parties do not act contrary to the spirit of the contract. We both know what was intended by the contract. We both know what the intention was. But I've got this contractual right, which I'm going to insist upon or I'm going to abuse in order to deprive you of obtaining what you anticipated, what you legitimately expected from the contract. So it's also linked into use of rights concept under civil law. For example, neither party shall do anything to prevent the other party from receiving the fruits of the contract. You can't deprive the other party of the benefit of the agreement or violate that party's intentions or reasonable expectations. So, case law, what's case law done with this? Well, in practice, duties can be viewed as mandating that contractual parties don't seek to evade the spirit of the bargain, do not limit their diligence in the performance of the contract, or deliberately slack off, or deliberately not perform their obligations, or perform them incorrectly, or abuse their power under the contract. And that they must not interfere with, so positive act, they must not deliberately interfere with, but nor must they fail to cooperate with the performance of any other party's obligations under the contract. Now, as I noted before, unlike in civil law, there's no obligation with regard to good faith in pre-contractual negotiations. Any negotiation in bad faith will have to be subject to rules such as the rules of misrepresentation, fraud, duress, etc., which would apply to those situations, but not a general concept of good faith. Now, I thought it might be helpful in the time remaining to look at a few concrete examples from some arbitrations that I've been involved with where good faith was key. First example, an international tobacco company has a 20-year license with a local licensee, Company A, to produce its products in a South American country. In year 18, the contract requires the company to enter into negotiations with Company A for a possible renewal of that license. There's no obligation to renew and no conditions established for renewal. Now, the international tobacco company starts the negotiations with Company A in year 18, just as the contract says it should. But what it doesn't do is tell Company A that it has already entered into an agreement in principle with a new licensee, Company B. Indeed, it enters into that new agreement with Company B the day after the license with Company A expired. Company A then brings a claim for breach of the duty of good faith, in particular for not negotiating in good faith, as it had no intention of signing an agreement with Company A during those negotiations. It committed itself in principle with Company B without telling Company A that was the case. And in that case, the argument on good faith was successful, the breach of the duty of good faith by the International Tobacco Company. The tribunal held that the International Tobacco Company was not performing its obligation to negotiate in good faith. And remember, that was a contractual obligation to negotiate in good faith. It's not a pre-contractual situation. But it's interesting to note that the damages were limited to the wasted costs of the negotiation, because there was no causal link, there was no obligation to enter into a new agreement with Company A. And therefore, in the absence of an obligation, the loss that Company A had suffered was the efforts that it had made to negotiate, but nothing more. Interestingly, let's imagine if that same situation had existed where you just had Company A and Company B with no pre-existing license, and that negotiations had been going on with Company A when the company already knew it was going to do a deal with Company B. In that situation, you would be dealing with a situation where there was no contract in existence. Good faith does not apply to pre-contractual negotiations. In that circumstance, there would have been no breach because, unlike civil law, there's no obligation in a pre-contract moment. Another case, which was a fun case, was an Asian billionaire who had lots of money but no knowledge of the art world, entered into a joint investment agreement with a South American art collector who had less money but good knowledge of the art world to invest up to $100 million of the Asian billionaire's money in a portfolio of modern art that would be jointly chosen with the South American art collector. Now, any decision under the contract to buy or sell had to be joint, but after 7 years of holding a particular piece of art, either party could demand a unilateral sale. Profits or losses would then be split equally. Now, they went ahead, they invested $100 million in a modern art collection. The modern art market then collapsed for a period of 6 years. And in year 7, the Asian billionaire decided he wanted out of this business and decided to put every single work up for sale in a single auction without consulting the South American art collector. That resulted in receipts of some $70 million, i.e. there were about $30 million of losses. The Asian billionaire commences an arbitration against the art collector for his half of the losses. The art collector defends the claim by arguing a breach of the implied duty of good faith and fair dealing by failing to consult him And he said, I would have advised against dumping all the pieces in a single auction and recommended that that be split between auctions and that certain pieces be sold privately or through galleries. I remember him explaining in disgust that you can't possibly sell 3 Picasso blue periods in a single sale. That would be suicide. So based upon that argument, the tribunal did hold that in good faith and fair dealing required that the spirit of the contract required as a minimum that the South American art collector be consulted before exercising the right of sale, even if there was no right to veto and no specific obligation to consult, particularly because the contract, the spirit of the contract, recognized that the expertise in the market lay with the partner, with the South American art collector. However, once again, the problem was in terms of what actual losses or how much of a defense that could be was complex, because how do you prove that had that good faith obligation been complied with, what difference would it actually have made in that particular case to how the portfolio would have been sold and how much more money would it have received? Final example, this is a quick example. Company A sells a renewable energy company to Company B under a sale and purchase agreement for an upfront payment and further payments if the project received all operational permits by a certain date or became operational by a certain date. So it's a split payment. You get some money up front, and if the project becomes operational by date A, you get another 20%. And if you get permits by a certain date, you get a further payment. Sorry, the other way around. So what happens? Company B then says, okay, great. I want to avoid paying those additional payments, so I'm going to delay my permit applications and deliberately create some problems in the application process so that those permits are not given to me until after the date has expired. And that way I can avoid paying the supplemental payments under the sale and purchase agreement. In that case, the company who had sold the company basically sued the acquirer, saying that if you had acted diligently and not abused your power under the contract, the dates would have been easily attained and we would have received the supplemental payments. In that case, ultimately the case was settled. I think looking at the facts of the case, one could imagine that the tribunal would have likely held if the blocking behavior had been proven, and of course it's highly fact dependent. You need to prove the bad faith to a certain extent, but there was strong evidence on the record that the payments indeed would have been due to Company A if it was clear that, but for that conduct, breach of the duty of good faith, the dates would have been met. So there are a few examples. I've already come to the end of my time, but just to note that under international law, good faith is a principle of the general principle of law enshrined in the Vienna Convention on the Law of Treaties, recognized by the International Court of Justice. And often when you see that treaties or customary law don't yield a result, recourse is made to general principles of law such as good faith. And when you see international legal rules such as Pakistan, Savanda, abuse of rights, estoppel, acquiescence, these are all concepts which we also recognize in municipal law and are frequently referred to by international courts and tribunals, particularly in investment cases, where actually if you look at some of what underpins fair and equitable treatment, really that comes down to an obligation of a state to act in good faith. It must act in accordance with the investor's legitimate expectations. It must not act in an arbitrary manner. All of that is sort of the equal and opposite of a good faith obligation. So really, one could say that most investment cases involve precisely the good faith of a state in the way it treats a foreign investment. So I won't hold anything more up to that. I think by way of conclusion, I fully agree with Roland. I think actually if you look at the content of the rules in the United States, you will find that with the question of negotiating a contract apart, the way in which the courts have approached the obligation of good faith is very similar to the way in which civil law courts would go about addressing this. It's a fact-specific exercise. You have to be honest, you have to follow the spirit of the contract, and you must cooperate with the other party. So I think in those circumstances, you might call it something different. There's no civil code, but at the end of the day, we're probably going to find that the same answer arises, whether or not you're looking at French law or the laws of New York. Thank you very much. And back to Sarah.
Thanks very much, Nigel. And you actually set me up for a perfect transition, not planned, but perfect. Because you started out by saying something interesting, and that is that under US law, the general presumption is that every party will carry out the contract, the performance and enforcement in good faith. And also you made reference to the fair and equitable treatment standard. I started practicing law in Texas, so I was first and foremost a Texan lawyer, really practicing investment arbitration law, because I started my career by practicing those Argentinian cases, the cases that arose out of the pacification crisis. And most of those cases were FET cases where it was based on the investor's legitimate expectations. So imagine my surprise as a Texan barred lawyer who was practicing international investment law, then transferring to London about 10 years ago, and finding out that under English law, there is no general doctrine of good faith. For me, this was quite striking, and I really thought it was quite, I didn't like it. I thought that was just contrary to an innate sense of justice that one should proceed when they're performing and enforcing a contract. And for me, it was quite odd that that wasn't a general doctrine under English law. And those practicing English law said, well, why would you want to invoke uncertainty that would come by implying these terms of good faith? And we have a saying in England, and it is what it says on the tin. And there used to be a famous commercial about this product being what it says on the tin. I think, I don't know if it was, someone will correct me who has lived here. I don't know if it was baked beans or something along that nature, but it was what it says on the tin. And I think one of the reasons that English law has been so popular, and I think it's one of England's most popular exports, is because it's very much a law that provides a great deal of certainty. Parties know that whatever they agree to will be respected, and courts are very reluctant to imply terms or to assume certain things about the parties. If you agreed a bad deal, you agreed a bad deal. You should have done a better job. And so I think over time, I've been here nearly 10 years now, and I've gotten much more comfortable with the concept that there is no general duty of good faith under English law, and that English law contracts are really based on the four corners of those contracts. They are what is agreed, and courts will work very hard to ensure that those contracts are performed in accordance with those terms, even if that might be unfair to one of the parties. Now, that being said, we have seen a shift in recent years, largely as a result of who used to be Justice Leggatt, and now it's Lord Justice Leggatt. He's been elevated to the Supreme Court, but he has taken a very different view of good faith, which is more akin to that which Roland and Nigel have been speaking about, more so Nigel, in the sense that it's really limited to the performance and the enforcement of contracts. But we, I guess, start with a different starting point, and that is that under English law, there is really no general doctrine of good faith. But that being said, there are three exceptions to this general rule. Now, the first exception is the express duty of good faith. And that is when the parties expressly agree that they're going to act in good faith. And the question then is, whether the words actually do impose a duty of good faith, and what that means in practice for the parties when they've done that. The second exception under English law is the rule of rationality, and sometimes this is called the Braganza rule, because this came out from a Supreme Court case. And this is a well-established, I would say very well-established by now, a duty of rationality under which a party who has discretion in the contractual relationship must exercise that discretion in good faith and not arbitrarily or capriciously. And then finally, there is an implied duty of good faith. And this is a situation in which the courts can imply a duty of good faith or the concept of good faith, depending upon the circumstances of the case. And these are usually likely to arise in relational contracts, joint ventures, franchise agreements, contracts that are of a long-term nature, where you would expect cooperation between the parties. So those are really the three exceptions under English rule to the general doctrine that there is no doctrine of good faith. Interestingly, I would also query, I think we've talked a little bit, and most historically, the people who would be arguing against a duty of good faith in English law would say that that's required because otherwise there'll be uncertainty in relation to obligations that are potentially vague and subjective. And I think the real concern here by those who do not wish to approach things the way Justice Leggatt would is that, you know, this might inhibit the goal of contractual certainty, and that is above and beyond everything else the goal under English law. So that is, I think, the impetus between some hostility against implying good faith, but I do think, again, that the trend is changing. So there's a great deal of flexibility just if you're going to put an express term in your contract on what you can say. And the courts have found that it really doesn't matter how you phrase it, you know, the utmost duty of good faith or a high level of good faith or good faith and fair dealing. There's no real gradations of good faith. It's pretty much going to be applied consistently throughout, no matter what the terminology is. However, one note of caution, if a party is going to put in an express duty of good faith in a contract that's governed by English law, they should be very specific about what obligations that applies to. Because again, courts are reluctant to apply that duty to the entire contract, especially if it's extremely long and complex contract. They are only going to want to apply it where it's really been specific that the parties intend for a particular provision to be interpreted in good faith. So it's important to keep that in mind when you're drafting. Now, in terms of what does this mean, and we talked a little bit, okay, we've got good faith, what does it mean? The courts have really interpreted this, the English courts, to act honestly, to be faithful to the parties' agreed common purpose, as is derived from the contract and the agreement. So again, they're going to look at the four corners of the contract. What is the commercial intent of the parties as judged by those terms of the contract? And is the parties' actions, are they consistent with that? They also find that good faith requires not using powers for an ulterior purpose, to deal fairly and openly with the other party, and to consider and take into account the party's own interests while having regard to the other party's interests. Now, to be clear, there is no requirement that any party reduce its own commercial interest or not act in its own commercial interest, even if that might be adverse to the other party. It is absolutely fine, and one would expect a business person to act in their own commercial interests. But it's really about acting honestly, fairly, similar to the concepts that have already been discussed by Roland and by Nigel. So some of the cases that have dealt with express duties and have interpreted these contracts have found them to have substantive effect in things like preventing actions that frustrate the purpose of the agreement, or requiring the disclosure of material facts to the other party. Express provisions of good faith have also been interpreted as prohibiting knowingly misleading a party, or prohibiting a party from having access to particular information that is required for open agreements. They've also prohibited parties from negotiating behind the other party's back and from knowingly sustaining groundless disputes. So those have all been instances where the English courts have said an express duty of good faith applies. Now, one important caveat on this is that an express duty of good faith won't cut across hard contractual rights. So, for example, if you have a contractual provision that allows a party to terminate for convenience, they're not going to imply good faith, as Roland mentioned, perhaps in the termination, to see if that termination was fair. Was it long enough to allow the party to be settled and make other arrangements? That typically will not be the case under English law. It will be whatever the arrangement is in terms of the notice period, and the courts will enforce that strictly. The good faith provision would not override that or undercut those solid, hard contractual rights, as we often call them. So going on to the next exception, which is really the rationality test, or the Braganza duty. That's essentially an implied obligation in the absence of clear language to the contrary, because parties can always contract out of this if they wish to exercise contractual discretion in good faith and not arbitrarily or capriciously. Now, that would normally mean the discretion has to be exercised consistent with the purpose of the contract. And also, it typically applies in cases where the party might not be on equal standing, the two parties. So there might be one party that has greater power, and it's often implied in those situations. So if you have a JV and one party is significantly more powerful, there'll be an obligation for the party who is making the discretionary decision to do so in good faith. I think by now, as I mentioned, this is considered a well-established principle under English law, and it will apply unless there's clear language to the contrary. And it's actually quite difficult to contract out of this type of a provision. So when does this typically come up? So the duty of rationality is really only likely to arise in limited situations. And this is typically when one party, who's the decision maker, is making a subjective decision on a matter that affects both of the parties, and that gives rise to a conflict of interest. So this conflict of interest is more likely to be found where there's a significant imbalance of power between the parties, and it's less likely, on the other hand, to apply when you've got two sophisticated business-to-business parties who've both sought legal advice and have expert legal services at their hand. And essentially, this is just really meant to act as a safety valve that protects parties against conduct that would be completely arbitrary or capricious. So it's not, again, a high standard, but rather it's meant to protect one party against abuse by the decision maker. And then moving on to the final implied duty of good faith, which is really one that has been seen as arising out of relational contracts. This is where I think the English law is moving, has certainly a trajectory towards U.S. law. And really Justice Leggatt, who is kind of behind this, he was one of the first justices to really question whether or not the English position was essentially swimming against the tide of other common law jurisdictions, and whether it was really correct to say that an implication of good faith allowed a situation where there wouldn't be contractual certainty. One of the first cases where he decided this was the Yam Seng case, and that was a case that dealt with a duty-free supplier of deodorants, which were related to Manchester United. So football is big over here. When I say that, I don't mean soccer. I do mean soccer for those in the U.S. And there was a Manchester United branded range of deodorants and perfumes, etc., that were going to be sold in a duty-free shop. Now, the partner that was going to sell those, the supplier decided to sell that product more cheaply outside of the airport, which kind of, as you can imagine, would undercut the purpose of duty-free, where people think they're getting a great, advantage to smell like a Manchester United football player for even less. So there was some undercutting of the long-term relationship. And what happened in that case is the seller, the duty-free seller of the product, had said, this was a breach of the implied duty of good faith, because we have a long-term relationship. I can't run a business if they're undercutting the price outside of the airport. And Justice Leggatt agreed. And he said that there was, in that type of a long-term relationship, there was a clear implied duty of good faith. And that's really where it kind of sent some ruffled the feathers of some people in the English law community. But really, the idea was, we have a long-term contract. These parties, to perform the contract and to really perform the objective of the contract, this should be done in good faith to further the object of the contract. So we're seeing a movement now in English law that really is focusing on relational contracts. Again, these are joint ventures, they're franchise agreements, anything of a long-term PFI contracts. All of these are contracts that are being interpreted more and more as implying a good faith nature. And Justice Leggatt, in his writings, has also indicated that he believes that the U.S. approach, as stated in the commercial code and also the restatement, the trees on steroids, I think, as you mentioned, Nigel, that is a correct approach, and that English law shouldn't swim against the tide and be contrary to that. So that is, I think we're heading in the right direction. And I see we only actually have 4 minutes left, and I do want to ask the panelists some questions. So I think I might start with there, and the concept of uncertainty and good faith somehow imposing uncertainty. I think as I was thinking about this, I was thinking the opposite. I mean, would you agree that it's actually the case that good faith can impose a level of certainty? And I'm thinking in particular in arbitration and investor-state arbitration, because often investors are required to really have good faith that the state, which is at a power imbalance to it, will act in accordance with good faith and will perform the agreement that the parties have reached in good faith, and that would essentially lead to greater certainty. Do you guys have views on whether or not good faith actually has a role of enhancing certainty in international law in that respect, as opposed to undercutting it, as historically the English law tradition has supposed? Nigel or Roland?
I'll have a first bash if you like, Sarah. I think you're right. I mean, I think if you imagine in any contract how many rights and obligations you could have in a complex contract, if essentially each party was free to abuse those rights, and you could sit there and think of how many ways those rights could be abused, and that would be fine, that creates enormous uncertainty. I think if you come into that contract knowing that overarching all of those rights and obligations is a duty to act in good faith, then you cease to worry about how a particular interpretation could be used against you, if you knew that would clearly be against the spirit of the contract. And therefore you worry less about that, and you're not trying to account for every possible element of bad faith that could occur. And I think in order to do that in a sort of a strict English approach where there's no duty of good faith whatsoever, I mean, every single obligation, you'd need to sit there and imagine how many ways could you be screwed by your counterparty, while at the same time following the letter of the obligation. And I think parties need to feel that once they're in a contract, there is a relationship, and that there should be certain standards of conduct that apply to that, and they certainly apply in the investor-state context. And indeed, that has really, I think perhaps informed a lot of what the evolution has been, is that the state has to act in good faith, particularly in international cases, both international contracts and international investments, where frequently the parties from different legal cultures, where they're not imbued with the niceties or very specific questions that local law has, and which is why you see international arbitration tribunals, I think, quite open to bringing in good faith concepts, because when you've got a Portuguese investor making an investment in the United Arab Emirates and a contract governed by English law, I mean, how many of those people are really thinking about what the niceties of English law are? It's just, English law is something that we're always told is a sensible law to put your contract under. But in general terms, have they really studied the impact? Quite often, there will be relatively limited involvement of English counsel. I think it does create that certainty, knowing that you have to behave reasonably and honestly. And most people, it's a bit like going back to the elephant, as Roland was saying. You might not be able to define it, but you know what good faith is. Most people know what performing a contract in good faith is. If you're trying to avoid the deadline to make the extra payment, and you're deliberately setting that up, you're acting in bad faith. So I think it's not as complex as people think, or doesn't create as much uncertainty as people think. And the opposite is probably true, because then if you have to assume that everyone is out to get you all the time in any contractual relationship, and there's nothing to protect you other than the harsh terms of the contract, then your contracts are going to have to be 3 or 4 times longer, and you need to be, and that's not efficient, I don't think, from the perspective of international commerce.
Ask one more question, Karim. Do I have time for one more question? And it's just on one difference I do see between civil law and common law is the pre-contractual negotiations. Under English law, the general position is that, and I think U.S. law is the same, it's the performance and the enforcement of the contract as opposed to the negotiation of that contract. Roland, are we right about that? Or does the civil law system resolve things more efficiently or in a superior manner? What is your position on pre-contractual negotiations and good faith in relation to those?
I wouldn't say that the civil law system resolve that in a superior manner, but definitely in an effective manner. At least it's an effective way to proceed. I would say that under French law, we have a number of provision which clearly imposes a good faith requirement, including on the negotiation, whether it's initiated, conducted, broken off, and that has important ramification. It is true that I would say negotiation can be adversarial by nature, but the good faith standard, at least I submit, calls for the parties better nature, if I may say so. And acting in good faith, from my perspective, does not mean you cannot aggressively put forward your position. It means that you should do so with honesty and integrity. And here, this is a very useful, I think, safeguard provided under certain civil law system. So that's at least my view. And to link it with what we mentioned earlier, again, we're back to the idea that it's a general principle which applies, at all level, and including at the initial part of the discussion in the negotiation itself, even if the contract is not yet concluded. So there is at least, I would say, some consistency and effectiveness within the system. But I fully acknowledge that it's an exception compared to common law jurisdiction from this perspective, at least.
Keep it the way it is, or should we move to pre-contractual phases?
I leave it to you.
Nigel, do you have any views?
I think it's very hard for a common law to think how you have to behave in good faith in negotiations. Does that mean that I have to think about what the other side should be worried about, as opposed to what I'm worried about, and what they think might be reasonable to know and not know? I think it's very hard in that circumstance. When you are in an adversarial position before you've reached a common position on anything, to be thinking about what those needs might be. And I think I prefer the common law approach to that. Although I'm fully in favor of good faith once the contract's signed.
Well, I think with that, we've run out of time, but I think what we can decipher from that is we can agree to disagree on those more fine points of good faith. But we can, I think, generally agree that good faith finds itself in both civil law systems, common law systems, be they the US system or the English system, and also, importantly, in the international law system. And I can imagine it would be much more difficult to negotiate with host states if we didn't have overriding principles of good faith that guided those contracts and those commitments. So with that, I'm going to pass it back over to Karim, and sorry for going slightly over.
Thank you very much, Sarah, and thank you very much to the three of you for this truly fantastic and thought-provoking panel. Now we're going to take a short 25-minute break, and we're going to get back here on the same link to panel 2, arbitrators' powers to review contracts, hardship, and force majeure in comparative perspective. Thank you very much.